Welcome to the Power of Offense with Keith and Rodney, and I'm your host, Big Keith. And this video is the second video of an ongoing series of videos that I shall complete, and there's going to be 5 videos total where I discuss prenuptial agreements and marriage. Now, if you haven't checked out the first video, I ask that you go down into the description box, click on the first video and check it out, because it's my response to a video that was done by Mr. Fantastic 824, in which he made some statements concerning prenuptials, of which I take exception to. Now, in quote, Mr. Fantastic said that prenups are purposeless. Now, he also said that if a prenup is signed under duress, then the prenup is invalidated. So we're going to take a look into that. Then he went on and said that a prenup can be invalidated from alleged occurrences of abuse. And I know he named, I want to say, about 5 different types of abuses. He pretty much covered all the abuse you can imagine, which would be like domestic abuse, verbal abuse, financial abuse. So we're going to take a look into that also. And then the last thing he said is that a prenup can be invalidated because it doesn't include child support and alimony. So I wanted to address those particular 3 talking points of which he made during his video. Now, right here on the screen, I have an article that's from Forbes magazine, and it's titled 5 Reasons Your Prenup Might Be Invalid. And we want to read this article. Now, it goes on and it says, if you live in the New York City area, you may have seen the news last month that a Brooklyn court threw out the prenuptial agreement a Long Island woman had signed with her millionaire husband before their 1998 wedding. This is a precedent-setting move, and divorce lawyers nationwide are sitting up and taking notice. Will more people now try to have prenuptial agreements tossed out of court? Long ago, having a prenuptial agreement was considered stodgy or even insulting, but these days prenups are becoming increasingly common for high net worth couples. Simply put, a prenup formalizes the understanding between spouses-to-be as to which of their assets will become marital property, which will continue to belong to whom individually, and in the event of a breakup down the road, what financial provisions are to be made. Most commonly, a prenup is drawn up to protect the spouse with the greater separate assets from losing an unfair proportion of that wealth if the marriage should end. Until recently, prenups were considered difficult to void. Indeed, I constantly advise brides-to-be to have a thoughtfully conceived prenup in place to protect their financial interests. However, it does sometimes happen that a woman who signs such an agreement and whose husband now wants a divorce has defensible grounds for wanting the agreement revoked. Here are 5 conditions under which that could happen. Now, number 1, the agreement is fraudulent. It says a prenuptial agreement requires each spouse to make full disclosure of his or her assets. In divorce, it is quite common for the husband to undervalue assets or fail to disclose them at all, so these assets can't be made part of a settlement agreement. Unfortunately, prenups are prone to this kind of underhandedness as well. If you can prove your husband did not fully disclose his income or assets at the time you signed the prenup, you may have grounds to have the agreement thrown out now that you're getting a divorce. So number 1, the first reason, right, would be if the agreement is fraudulent. So if the agreement is fraudulent, we know, right, that if the husband or wife undervalues their assets or don't fully disclose what their assets are, what they are, and where they exist, then a prenup can be invalidated. Number 2, the agreement was coerced, signed under duress, or signed without mental capacity. Coercion or duress can be extremely difficult to prove. And as with many aspects of divorce law, different states have different standards for what it means to have been coerced into an agreement. Still, it is not unheard of for a prenup to be thrown out on this basis. Similarly, if you can prove that you lack mental capacity to understand the prenup when you signed it, for example, if you were ill or under the influence of drugs, this may be a sound reason to invalidate it. So, if this prenuptial agreement was signed, right, through coercion or duress, meaning that this person was forced into signing it, or that this individual, signed it but wasn't in the right state of mind, they lack mental capacity, then a prenuptial can be invalidated. So Mr. Fantastic was right when he said if it's signed under duress. But as you can see, the article clearly states that coercion or duress can be extremely difficult to prove. And I can assure you that it is, especially if you follow certain methods in having the agreement signed. And those things are something that we will cover later. Now, number 3, it says the paperwork wasn't properly filed in the first place. As with any legal contract, the enforceability of a prenup can come down to the proverbial crossed T's and dotted I's. Careless errors can render a prenup less than airtight. If the initial agreement was poorly drafted, it may also be invalid. So that's number 3. So basically, if your paperwork was not filed properly, right, then the prenup can be invalidated. If the agreement is written poorly, if the agreement doesn't make sense, then obviously it can be invalidated. Now, the fourth reason is you signed without proper legal representation. And it says both parties to a prenup should have separate and independent counsel. In fact, some states actually require that they do. So some states require that you and your wife-to-be, right, have separate legal counsel that's there with you, representing you during your signing of a prenup. So you want to take a look at your state laws. It says if you sign something that your wealthy fiance or his family arranged to be drawn up for you to agree to in order for him to marry you, be aware that this may not be an ironclad agreement if years later he wants out of the marriage. Signing a contract without legal representation is never a good idea. But if that's how you signed your prenup, there may be a chance of invalidating it. So again, you want to make sure you understand the laws of your state, because the state laws governs, right, the institution of marriage. So you want to make sure that you understand your state laws in reference to prenuptial agreements. So again, if you don't have proper legal representation, then yes, the prenup can be invalidated. Now, number 5. It says the agreement contains ridiculous provisions or is simply too lopsided. Even though divorce court judges are typically disinterested in most peculiarities of individual contracts, there can be factors that raises eyebrows. For instance, if your prenup states no child support whatsoever will be paid in the event of a divorce, it is likely to be thrown out. Provisions in the prenup about weight gain, hair color, frequency of sexual relations, visits by in-laws. Remember, the judges have heard it all and are likely not to hold up in court either. So basically, the document cannot be lopsided. And to deal with the talking point of child support and alimony, I know Mr. Fantastic stated that prenuptials don't have child support and alimony. Well, a prenuptial should give some type of stipulation for child support and alimony in the event that a child is born out of this union, and alimony just in case you do have a divorce. So all of this can be laid out in your prenuptial agreement, and it should be. And if it's not, then that agreement can be considered lopsided, and in that prenuptial agreement can be invalidated in court. And of course you can't say things like, if she gains weight, if she gains 50 pounds, then basically she agreed that I can divorce her. That's unacceptable. Hair color, again, like it talks about frequency of sexual relations, all of those things are unacceptable. Now it goes on to say right here in summary, in order for a prenup to be effective, both parties must have their own separate attorney, right? Now that's true in some cases. In some states, you do have to have your own separate attorney. It says, plus the prenup must be written, because oral prenups are invalid, or they're not valid. It says it must be executed voluntarily and without coercion. A prenup that's signed the day before the wedding can be invalidated. But then it says executed only after full disclosure. Of course, there must be full disclosure. If you hide your assets and or liabilities, you run the risk of invalidating the prenup. So you definitely don't want to do that. It must be conscionable. A prenup cannot be unconscionable. In other words, the prenup could be invalidated if the agreement is too lopsided, with one party awarded almost everything and the other party receiving only a pittance. Then the next reason would be executed by both parties, preferably in front of witnesses or a notary. I agree with that 100% too. I'm going to discuss that later in another video in the series. It says some attorneys even recommend having a judge witness the signing to make sure that neither party was coerced into signing. And then it says written in a recordable format, such as a real estate deed. I agree with that. You definitely want to have the prenup written in a recordable format. And then the article goes on and it says, keep these conditions in mind. Not only if you are trying to get out of a prenup you now believe to be unfair, but also if you're thinking about signing one. Whichever side of the coin you're on, whether you're trying to void an agreement or trying to draft one that cannot be voided, it is critically important to consult with professionals who have the expertise to help you navigate these sometimes choppy waters and plan for a secure financial future. I definitely agree with them in that particular statement. Most people need an attorney to assist them with matters like this. Again, some states you have to have an attorney. We covered signing under duress. So Mr. Fantastic is 100% correct when it comes to signing a prenup under duress. He's also right as far as child support and alimony. If there's no mention of child support and alimony, then the prenuptial will be considered lopsided and it can be invalidated. Now, as far as the alleged occurrences of abuse, I found this write-up by the McNamara Law Office, and I thought this was pretty cool because they specifically addressed alleged occurrences of abuse. Now, right here, it says, can spousal abuse or cheating invalidate a prenuptial or partition agreement? It says spousal abuse or cheating does not void or invalidate a prenuptial or partition agreement unless the agreement specifically states that. So let's get that clear. That physical abuse or any type of abuse or cheating do not invalidate the agreement unless the agreement specifically states that. And the reason that's the case is because the contract makes the law. That's a legal maxim. Now I'm going to go into legal maxims dealing with contracts later in the series. But that is a legal maxim, that the contract makes the law. Okay? So in part, Mr. Fantastic is correct when he says alleged occurrences of abuse can, and the best way to put it is can, not that it will, but that it can invalidate a prenup. But it can only invalidate a prenup if it's in the actual prenup. That's it. Now they go on and they say most prenuptial or petition agreements do not mention abuse or cheating. Those agreements include provisions for division of property and sometimes spousal support in the event of a divorce. A custom marital agreement can include an infidelity clause, but the ramifications should be carefully considered. It could open both parties to litigation if one believes or just alleges the other has been unfaithful. First, basic definitions must be considered. Now, I agree with these attorneys 100%. Everything they said is spot on. So, in part, Mr. Fantastic is correct that occurrences of abuse can, not that it will, but it can invalidate the prenuptial if it is stipulated in that particular prenuptial agreement. So, thank you for listening, and I'll see you on the next video. Please drop a comment below. Peace.